Sorry, my lord, I was to take cue. My name is Sam Nyaberi. You gave indications and directions earlier that we take 2 minutes. I wish to call upon Waithera, who was on her feet before, so that I donate my time to her in the spirit of nurturing young talent, and so that she can also raise a fee note to be paid.
Ms. Waithera, how are you?
I'm fine, thank you, my lord.
You have been donated time, so take it and make your submissions.
Thank you, my senior Mr. Nyaberi. My name is Wanjiko Waithera for the 9th petitioner. And taking off from where my senior Mr. Wamboi left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have the applications dismissed on account that Parliament has the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKLR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts, as defenders and protectors of the Constitution, have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my ladies, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my lady, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles of this country. Thank you.
Thank you.
My lord, having heard that, we organize Ms. Omari will do a wrap for 30 seconds or 1 minute.
I hope you meant 30 seconds.
My lord, I didn't want to talk, except that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number 2, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency levels. Can that be the position that this court will uphold? I beg that the court extends the grant of the conservatory orders. Thank you very much, my lords and my lady.
Thank you.
Your Lordship and my lady, my name is Sakimpa. For the third petitioner, we'll be sharing time with my colleague, Mr. Wathuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by my learned seniors, so I'll only put into context in our petition. Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you.
Yeah, thank you. Thank you very much. Very briefly, my lord. And I'll just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought in that application, my lord, that application is moot. I say so because the substantive prayer number 2, was that pending the inter partes hearing of this application for setting aside, that the orders issued by Justice Chacha Mwita be varied or set aside. My lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this honorable court be pleased to set aside, vary or discharge the ex parte orders issued on 18th October 2024. My lord, those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court's work easy, there will be no need to consider that application. Having said that, and in view of your previous directions, that this application will be treated as a response to the application for conservatory orders, I would just like to make 2 or 3 remarks with regard to the content of that application, my lord. And I would just like to mention that paragraph 7 of the supporting affidavit sworn by the Solicitor General. Actually, it is in the ground, but then it is reflected in it is in ground number 7, my lord. It says, Article 1 of the Constitution, provide that the sovereign power belongs to the people, and that where there is a conflict between public interest and private interest, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of a president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed, varied, or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just 1 minute. I'd like to make a remark, still to make the court's work easy, in a petition number 15. And my Lord, again, that application is moot. I had to check the one that is on CTS just to be double sure. And the substantive prayers that are sought are prayer number 3. It was an interim order pending inter partes hearing of that application. My Lord, again, we are beyond that stage. We are already at the inter partes stage of the hearing. So the remaining prayer is prayer number 4. And allow me to read it verbatim. That this court be pleased to set aside, review, or otherwise vary grant the ex parte orders issued on 18th October 2024 by Honorable Justice Mwongo Richard Mururu in Kerugoya Constitutional Petition number 15, pending the hearing and determination of the appeal. My Lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is moot. Turning to the content of that application, in as far as it is a response to the application for conservatory order, firstly, the decision or the subject of the petition before that court was the proceedings before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than the bereaved. Again, if you look at paragraph 6 of the supporting affidavit, shown by paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, my Lord. Temporarily set it aside. pending the hearing of the appeal. My Lord, that is not an appropriate ground because no appeal has been placed before you. At paragraph 7, which is a serious misconception. Yes, my Lord.
You had very few minutes. I think you have exhausted them.
Judge, I beg only two. Only two, Judge. Thank you. At paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. My Lord, one of the reasons why we have the current constitution is to prevent this very mischief. So, we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So, this is a process
Lord,
that is...
objection, that is evidence from the bar.
I'm just picking a paragraph in the supporting affidavit.
Mr. Watuta,
Yes, Judge.
please conclude your remarks.
Very well. Thank you. Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My Lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we will demonstrate at the hearing of the petition, is just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we'll deal with at the petition stage. But all in all, my Lord, you only have two applications to consider, the ones for conservatory orders. The one for setting aside the conservatory orders, my Lord, I've made your work easier. Most obliged. Thank you very much.
Thank you.